All right. I think that we should restart, and I would like to restart with the formality of the court heading. So Ms. Oswald, please, would you read out the court heading?
Friday, the 11th day of March, 2022, court at 10:14 a.m. before Honorable Justice Sybil Williams, Civil Jurisdiction 2016, number 183. In the matter of Energy Development Group Limited, Appleby for the petitioner, Mark Borges for the creditor, and Christian Luthi for the creditor, and Kevin Taylor for the JPLs.
Thank you, Ms. Oswald. Mr. Wassey, can you just correct, please, the appearances?
Yes, milady.
Thank you.
I appear on behalf of the petitioner, Credit Suisse AG Singapore branch. My learned friend, Mr. Taylor, appears on behalf of the joint provisional liquidators. Mr. Luthi and Ms. Zewell, they have appeared in previous hearings in this matter, but they have advised us they have no instructions to attend today.
Thank you.
30 minutes ago, we received a notice of intention to appear from MJM Limited, and Ms. Howarth appears today on behalf of a company named Ultima Top Limited. I don't know if your ladyship has received that notice of intention to appear.
I don't believe that I have, and if I have, I've not seen it.
Right.
My lady, no, we have not yet filed it with the court. We circulated it with the parties, but intend to file it shortly with the court. So you will not have that in front of you as of yet.
In the email that purported to serve the notice of intention to appear half an hour ago, Ms. Howarth indicated that the instructions from her clients were that they wanted to seek a 2 to 4 week adjournment to consider a proposal that would be put forward.
Thank you.
And what I would like to do, milady, if I may, is address the court as to why Ultimate Top Limited should not be allowed to appear today, because they're in default of the company's winding up rules. And secondly, to take your ladyship to an extempore ruling on an application to adjourn the petition.
Yes.
From Justice Kawley in 2017.
Yes.
So first of all, dealing with the notice of intention to appear, there is no indication on its face or in the email we received from Ms. Howarth as to the relationship between her client and the company.
Mm-hmm.
Not stated whether it's a creditor, a member, no indication of that whatsoever. More importantly, the notice of intention to appear is out of time. The rules governing that are the company's winding up rules 1982, in particular Rule 25, notice by persons who intend to appear on the petition. I don't know if your ladyship has those in front of you.
Not to hand, but do I need to?
I'll just quickly run you through. I'll just quickly run you through them. Yeah, Rule 25.1 stipulates that every person who intends to appear on the hearing of a petition shall give the petitioner notice of their intention in accordance with the rule. Rule 25.4 stipulates that a person who sends such a notice, it must reach the petitioner by 4 p.m. on the day before the hearing. That's 4 p.m. yesterday. And Rule 25.5 provides that a person who has failed to comply with this rule shall not, without special leave of the court, be allowed to appear on the hearing of the petition. So our position is that the notice of intention has been filed too late, and therefore Ms. Howarth is not allowed to appear on the petition today for her client.
Right.
That is buttressed by the observations in the ruling of Justice Kawley in 2017 in this matter. I don't know if you will have that quickly on the file, but if I might take your ladyship to some passages on that. The heading is ex tempore ruling on an application to adjourn the petition.
Yes,
Do you want me to give you some time to look for that, or shall I just?
that's fine. You can continue.
Okay. It's dated the 13th of October 2017. I appeared on behalf of the petitioner. Mr. Taylor and Ms. Tovey appeared on behalf of the JPLs. Mr. Martin and Ms. Howarth appeared on behalf of Kaisen Energy Group,
Yes,
a creditor which at that time was supporting the adjournment application. And Mr. Burrows appeared for Zuel & Co. on behalf of Bow Steel. In addressing the principle which governs whether an adjournment should be allowed, Justice Kawley set that out at paragraph 5. He said, the principle which is really brought into play by the application for an adjournment is a very short one, and that is that, quote, the court is given a broad discretion to adjourn a petition for good reason. And the authority for that was Re ZOB Holdings Limited, 2017, Bermuda LR 19. In considering that principle, at paragraph 6, Justice Kawley noted that it is broadly agreed that a petitioning creditor is petitioning not in pursuit of its individual interest, but rather its class interests. And so the best interests of the unsecured creditors as a whole must be taken into account. And he goes on to say, and in that regard, it is significant that there is credible evidence before the court that the majority of unsecured creditors support an adjournment of the petition, despite the concerns the petitioner has raised. Now, it goes without saying that having just received notice of intention to appear 30 minutes ago, there is no such evidence before this court. This is one company whose status is unknown, seeking adjournment very late. Secondly, Justice Kawley went on to say, the judgment of the majority of the unsecured creditors does not stand alone, because the JPLs who have been appointed by this court on behalf of the funding creditor are the eyes and ears of the court, positively recommend that attempts to pursue a restructuring be pursued. Again, there is no such evidence from the JPLs today. As I will come on to address you in why this company should be wound up today, the JPLs do not oppose a winding up order being made today, and they have good reasons for doing so. At paragraph 9 of the ex tempore ruling, Justice Kawley said, the credibility of the JPL's initial assessment is, to my mind, fortified by the fact that they have not adopted the simplistic approach of merely saying that there will be a nil recovery. That was on the basis that there was no restructuring. Again,
Mr. Watson, I have to say, I wonder if it really was quite prudent for me to hear from you first. If there is an application for an adjournment being sought and an application for special leave of the court to be heard, I wonder if it makes sense to hear the application first, and then you can directly respond to it. Because you're citing general principles that may or may not be in dispute. There may be a narrow point that Ms. Hayworth wants to address me on. I don't know. Yes, why don't I just hear from Ms. Hayworth and then you can respond.
yes, my lady.
I'm very
Sorry,
grateful.
Ms. Hayworth, before you start, Ms. Oswald, can I seek your assistance in my chambers, please? Thank you. Yes.
I'm very grateful, my lady. This morning, as indicated by my learned friend, I appear on behalf of Ultima Top Limited, having received instructions overnight, quite literally within 12 hours. So I'm in a position, quite a position, I guess, of deficit as it relates to the background and information as it relates to this matter relative to the other parties. What I can say is that my instructions are that Ultima quite recently acquired a charge in relation to, well, it effectively was assigned a loan that had previously been held by China Mingsheng Banking Corporation, Hong Kong branch.
Okay, just pause there for a moment, please, Ms. Hayward.
Yes.
Thank you. All right, I think my computer froze. Can you hear me?
I can, yes.
All right. Except my computer's just blanked. I don't know if you can still see and hear me.
I can
I
both
have a
see,
blank screen.
I can both see and hear you.
Okay, good. All right, it's back. Thank you.
Your Ladyship,
Ultima was assigned a loan, you said.
exactly. Ultima was assigned a loan from China Mengsheng Bank Corporation Hong Kong branch quite recently, which was a loan between CMBC and Up Energy Group Limited, which I understand is a controlling shareholder of the entity, which is the subject of these proceedings. My understanding, my lady, is that Ultima, therefore, is appearing as a creditor or contingent creditor in this matter, standing in the shoes effectively of CMBC in relation to this matter. It's on that basis that we say that Ultima has relative sort of standing to appear this morning. And we would ask your ladyship to consider special leave provisions in the circumstances of having been instructed at such a late stage before this matter, before this hearing, and in circumstances where Ultima's, the assignment only took place very recently. My instructions, as I say, were I circulated this morning a notice of intention to appear to the parties, wanting them to have awareness as soon as possible. And we certainly undertake to file that as soon as this hearing is completed, assuming the court gives us leave to do so and to appear this morning. As I say, we appreciate that this matter has been going on for quite some time.
But before you get to Ms. Hayworth, I don't know if I have understood from you clearly. Your client would ultimately be supporting the petition, would be objecting to it? I mean, what would be the...
Ultimately, my understanding, my lady, is the cut and thrust of the seeking of the adjournment of the hearing is so that a proposal may be presented to the JPLs and ultimately for consideration of creditors in due course.
What type of proposal?
I really have very, very limited instructions, but my understanding would be it would be some kind of restructuring proposal. And I'm happy to address your ladyship further as to why we say an adjournment is appropriate in circumstances, but I don't want to get ahead of myself.
No, I think you should. I think
okay.
I think you should make all of the points that might support your application no before I hear from Mr. Rusty.
I'm grateful, and I don't have a great deal of submissions, as one can imagine. The instructions are limited at this time, but my understanding is that the CMBC loan, which has recently been assigned, as I say, to Ultima, accounts for Hong Kong 2.7 to 2.8 billion, which I understand is more than 50% of the principal debt amount owed by the company in this matter. As I say, my instructions are fairly limited, but I understand that the adjournment is sought on the basis of a proposal being presented, seeking to a further restructuring proposal be presented to the JPLs and to creditors in due course. I understand that if a winding up order is to be made in this matter at this time, it may put certain mining licenses of the companies at substantial risk. And I think the sort of cut and thrust of it is, my lady, that although significant time has passed, my submissions this morning are that there would be no great urgency with a winding up order today as compared to 2 or 4 weeks from today, in circumstances where this matter has been going on for a number of years, 6 years. The risk of a winding up order, again, my instructions today are that with the mining licenses being revoked, there's a risk to creditors that they may in fact have a zero return, as opposed to a short adjournment, which may give rise to a proposal, which may have the possibility of something different.
I mean, your client would be a contingent or prospective secured creditor,
That's my understanding, my lady, yes.
and that would hold presumably significantly so as well, much less weight than the position of the unsecured creditors.
Understood.
Okay. Did you want to add anything else before I hear from Mr. Wasty and Mr. Taylor?
No, I don't think so, my lady. I think that's it at this time.
Okay, thank you, Ms.
Thank
Lee.
you.
Yes, Mr. Wasty.
Thank you, milady. I have heard my learned friend's submissions. Your ladyship picked up on the point that I picked up on immediately, which is that my learned friend's client does appear to be a contingent secured creditor, and therefore in the circumstances would be able to enforce its security irrespective of whether this winding order is made up or is made today. Secondly, the point about the prejudice, if the winding up order is made and the mining license is being prejudiced, the JPLs had no concern about that. That has not been expressed in their reports, and Mr. Taylor may wish to speak to that. Thirdly, my learned friend suggests that there is no prejudice by a short delay. My learned friend's submissions were that there would be an adjournment of 2 to 4 weeks, and then a restructuring proposal would be submitted. So that is open-ended in my submissions, milady. And the obvious prejudice that is caused is more costs in a matter in which very significant costs have been incurred by a number of parties and the JPLs over the past 6 years since this petition was filed.
Yeah.
I laid out some principles from the ex-tempore ruling. I don't need to repeat those, but I would like to pick up on some of the further points that were made, because I think they're germane to my learned friend's submissions.
Yes.
First, paragraph 15, in considering the viability of a scheme which was being presented at that time, this is back in 2007.
Mr. Wasty, I'm listening to you cite from this ruling. I don't have it in front of me, but can you just give me the date of the decision, please?
I certainly can, Liddy. It's 13th October,
Thank you.
2017.
Thank you.
At paragraph 15, Justice Cayley said, the viability of this scheme, despite the support which the proposal of a restructuring presently has, reflecting majority support, hangs by a very thin thread indeed. So even then, when it was supported by JPLs and majority, the Chief Justice was skeptical of what was going on. And he went on to say that there would have to be progress shown very quickly. That was 6 years ago. We have got nowhere on that. All of the restructuring of this company has been contingent on primarily the company resuming its Hong Kong Stock Exchange listing. And I was going to come on to address that in my submissions as to why a winding up order should be made. The company's time and opportunity for that relisting to happen have expired. The JPLs concede that, the company accepts that. It was 3 strikes and you're out with the Hong Kong exchange. They attempted a judicial review before the Hong Kong court. Permission for judicial review was refused. There is no prospect of this company being relisted on the Hong Kong exchange. And therefore, in our submissions, there is no prospect of a successful restructuring of this company. And that is what this court, the Hong Kong court, have been giving ample time to the JPLs to consider, and which they have duly done. And no submissions are made that was untoward. They have done what they were supposed to do, but it has come to an end. And we say that this last minute, late filed notice of intention to appear by a secured creditor cannot be supported, or should not, in our respectful submission, be supported by this court. We advertised this petition. We had advertised this petition many years ago. But because we saw
Sorry, we advertised the petition. I didn't hear what you said after that.
Sorry, many years ago,
Yes.
when it was first filed and when we were first seeking a winding up order. But because so many years had gone by, we decided that it would be prudent to re-advertise the petition again before this hearing.
Yes.
And that is at page 45 of the exhibit to Ms. Vaswani's affidavit,
Yes.
which is at tab 6 of the hearing bundle. So everyone has been on notice since the 25th of February that we were seeking to wind the company up today.
Yes.
And despite that, I would suggest that this court might believe that any transaction whereby this secured charge was being assigned to Ultimate Top Limited took some time to occur, and this notice could have been filed before then, not within half an hour before the hearing. Returning back to the extempore ruling, Justice Cayley, again, at paragraph 16, he said, by the hearing of the next petition, clearly progress would have to be demonstrated. And our submissions are that this would not be progress. This would be putting the company and the JPLs and the creditors back to square one, where we were 6 years ago when we started in this hopeless task. Again, no prospect of the company being relisted on the Hong Kong exchange. And again, inevitably, there's going to be an increase in costs of the parties having to come back, hear what this proposal is. They're secured. There's no benefit to the unsecured creditors in prolonging this. And we would suggest in the circumstances that there's no basis on which an adjournment should be made. I think those are my submissions in response to my.
Thank you, Mr. Lusty. I'll hear no from Mr. Taylor, please.
Buddy, thank you. Good morning.
Good morning.
The PLs don't have much to add other than what they've recently reported. Very high level here's what's taken place. You recall that, my lady, you sanctioned a scheme. The creditors voted and approved that scheme prior to your sanction order. My learned friend, Mr. Wassey, is quite right. Sort of one of the sort of linchpin conditions, perhaps the linchpin condition was.
Sorry, Mr. Taylor, can I ask you to just raise your voice?
Yes, let's say
Or
that.
increase
Is
volume
that
on your
is that better, my lady? Is
Much,
that better?
thank you.
Yes, thank you. One of the linchpins of the restructuring embodied in the scheme of arrangement was indeed the relisting of the company's shares on the Hong Kong Exchange. That condition did not take place, and as such, the scheme failed. And I can confirm that of course, that restructuring then is at an end. At present, there is nothing on the table there, certainly as far as my most recent instructions of last evening and even early this morning, there's nothing new for the PLs to report in that regard.
Mhm.
And so the JPL's position is, I don't have much to add. The reports are self-explanatory. We take a neutral position on the petition, but there is no restructuring in the offing today. So I'm able to confirm that for my clients. Lady, unless you have anything further, I mean, I will say one thing about the mining licenses, only because some time ago, in previous reports that I don't think form the bundle, the provisional liquidators did indicate to the court that it would be possible that if a winding up order was made, that would affect the mining licenses. But I suppose the position is, there's no further evidence of that today, and there's nothing further to tell you about that because, certainly I didn't come prepared to address that issue today. It's in previous reports, and but I don't have any further submissions, my lady, unless you have questions for me.
No, thank you very much, Mr.
I'm
Taylor.
obliged, my lady. Thank you.
Ms. Hayworth, did you want to respond to any points? Ms. Hayworth?
I think the only thing that I will say, and I certainly don't want to prolong things too much. I think your ladyship has the key points, but absolutely appreciate that the court's in a difficult position without anything material before it. But certainly a short adjournment would give us the opportunity to put something before the court and put the court in a better position to really consider this. So I would mention that I think for the court's consideration, that a short adjournment would give the opportunity to put some evidence for consideration before the court in order to make a proper determination on this point. But ultimately, I fully appreciate that I'm in your ladyship's hands, and I've heard the submissions and made the points that I could to your ladyship this morning.
Thank you. The court's position is this. It is more than difficult to envisage what might be put before the court by a secured creditor that would take any sort of priority or precedence over the position of the class of unsecured creditors. This is a matter which has a considerably long history. I myself have put out some interim rulings where applications for adjournments were sought and bitterly fought. There was much resistance at one stage to the efforts made by other unsecured creditors for the petition to be adjourned to enable and to assist the progress of what was then on the table as a hopeful and viable restructuring scheme. I have to take into consideration the fact that the company's shares, after yet again another long and bitter fight, it was determined at the end that those shares would not be relisted on the Hong Kong Stock Exchange. And I think that that is a very compelling factor for this court to consider when assessing broadly what the prospects might be for a restructuring. But even more so, I've heard directly from the JPLs that there is no such hope on the table as matters stand currently. In my judgment, despite all efforts, and the efforts were great, the end has now come. And it seems to me that this court really is bound to grant the petition for the winding up. It is unclear to this court what Ms. Hayworth's company, I'll refer to it as Ultima, as we have been doing, could possibly put before this court in a 2 to 4 week period that would stand against those real obstructive factors, such as the company not now being in a position to be relisted on the Hong Kong Stock Exchange. It would seem to me that this court would be in no better or different of a position in 2 to 4 weeks from now. The likely position I would expect would be that there would then be arguments as to whether or not the proposal should be further detailed, whether it has any flight. And I expect I would hear very strong and compelling arguments that it would not, because of the reality of the company's shares now being refused ultimately for relisting. So with all of those factors in mind, I do think that there would be great prejudice to continue to protract matters. This is a matter that has been before the courts. The petition has been before the court longer than I have been appointed as a judge of the commercial court. So I have to recognize that the history even predates my involvement. And I certainly would align myself with the principles that have been enunciated in the rulings, as the points, certainly the key points that I've heard from Mr. Wasti in reciting then Chief Justice Cavali's 13th of October 2017 judgment, but also other rulings which have been delivered since which. So those are, broadly speaking, my reasons for refusing the application for an adjournment and for granting the petition and making an order for the company to be wound up. So I think at this point I should know, just hear from Mr. Wasti briefly. I do have a draft order in front of me. Can you just take me through that briefly at this point?
Yes, I can, milady. Thank you for that indication and for making the winding up order. Turning to the draft order, it's an order in the usual terms. It provides for the current JPLs to continue in their position. That's at subparagraph 3. It also provides that Joel Edwards of EY Bermuda shall be appointed as an additional JPL to meet the residence requirements, which have since come into place. Mr. Edwards' consent to act is attached to Ms. Vaswani's affidavit. I don't know if you saw that, but it's the last page, or, page 46 at tab 6.
Yeah, I did see it. Thank you. Yes.
It provides that subparagraph 4 that the JPL's powers shall not be limited and that they are granted the powers contained in section 1C75, and that their powers shall be exercised jointly and severally. And it makes the usual order in relation to costs pursuant to Rule 141A, the winding up rules. My learned friend, Mr. Taylor, and I have discussed the cost order, consider it to be the appropriate wording, and that it affords the appropriate priority and costs to the petitioner. And of course, the petitioner's costs will be taxed. And we submit that it is the appropriate order on costs in that we have succeeded in securing the winding up of the company over the past 6 years. And that order winding the company up is for the benefit of the class, although it's an investment that we made on behalf of that class.
I should have also stated that the court refuses special leave to Ultima to be heard.
I had assumed that, my lady, but thank you.
All right. Mr. Taylor, did you have any comments on the draft order?
My lady, in anticipation of the possibility of the order being made, I agree with my learned friend as to the terms. In relation to costs, I do want to record for the court the exchange between counsel for the petitioner and the provisional liquidators that took place in relation to that provision. It should be obvious we submit, but there's been an acknowledgement and agreement between the parties that the costs expended by the provisional liquidators and their counsel's agents, etc., that have been previously approved by this court through fee applications, and any future fee application up to the date of the winding up order will take the usual priority that provisional liquidator costs will, which is a first priority. And I think the orders throughout indicate that that's the case. I discussed this with my learned friend, Mr. Wastia, and Ms. Vaswani at his chambers, and such that it doesn't impact that priority. Going forward, the priority as to the petitioner's costs will fall in line with the provisions of 140. And I merely wanted to record that for the record. Otherwise, we're content with the form of draft order that's been presented, of course, subject to my lady's viewpoint.
Thank you.
And I fully endorse that, my learned friend's view on that point, my lady.
Sorry.
I fully endorse my learned friend's views on that point, my lady.
I'm grateful to my learned friend. Thank you.
And should there, I suppose it could be in a separate order, but should there be also an order formalized where I refused? I mean, we haven't had really a notice of intention to appear to be filed, but there was still an application before me.
Yes, I submit, my lady, that we submit a draft order which will provide that notwithstanding a notice of intention was served outside the provisions of Rule 25, that the application was heard, and that it was rejected, particularly on the basis of any special leave being granted by this court.
Yes.
And I will circulate that to my learned friends and then to your ladyship.
Thank you very much. All right, I will sign the draft order in front of me in the terms as drafted. I don't know if there is this just a draft or is, oh no, this is a full copy. So I have signed the original with the revenue stamps, and I think copies can be made from that.
Indeed, I'm very grateful, my lady.
All right, thank you. Unless there's anything further, we can adjourn.
Thank you, my lady.
My lady, thank you.
Thank you.